Thank you very much. Dear organizers, dear professors, dear colleagues, I'm truly honored and delighted to be here because there's the good opportunity to exchange knowledge, experiences, and also to meet not regarding the age, but regarding the years which are we meeting together, old friends here in our beautiful Budapest. Thank you for invitation and to possibility to be part of this project and conference. The title of my presentation is Intersection, and Pavel introduced that law and medicine, and I added that should be also ethics. But for ethics, law and medicine, liability for prenatal harm in art procedures. And we already heard that Sandra opened some topics. I will also open, but not with the full introduction because there's no time, because we can make discussion all day long just regarding one of these topics. But I think there will be some very interesting issues which will be addressed in my presentation. Infertility is a disease of the male or female reproductive system, which is defined as the failure to achieve a pregnancy after 12 months or even more of regular unprotected sexual intercourse. Infertility today affects millions of people, not even in Slovenia, not even Europe, but all across the world. And this has also the impact on their families and communities. It is estimated that approximately one in every 6 of people in the reproductive age worldwide is experiencing the infertility in their lifetime. Infertility could be primary, that is when a pregnancy has never been achieved by a person, or secondary infertility, that is when at least one prior pregnancy. You see, we are not speaking about having already a child, but just about the pregnancy, so that it's not necessary that the child was born. The secondary, this one prior pregnancy has been achieved. When natural conception is impossible and the underlying problem untreatable, medical intervention can reproduce the steps necessary for fertilization and early embryo development. Assisted reproductive technologies, procedures, short art, encompasses a variety of medical techniques designed to aid individuals and couples facing infertility. They also involve manipulation of sperm and ova and embryos in vitro with the goal to producing a pregnancy. I found very interesting information. It was an American research that it is estimated that by the year 2100 there will be from 200 to 400 million people which will be born thanks to assisted reproductive technologies and also in vitro fertilizations. Art can help many couples to receive a child and to fulfill their wish to be a family. However, we are facing the questions: which potential consequences may be associated with assisted reproductive technologies and how they could impact an unborn child. Prenatal harm therefore refers to the injury or harm inflicted on the fetus during pregnancy, which can be caused by external factors such as drugs, alcohol, also accidents, if someone is hitting the pregnant woman in the stomach, or even medical negligence, but also in the art procedures. This harm may result in the birth defects, developmental issues, or other health problems for the child after the birth. The prenatal harm could be caused based on the errors during the assistive reproductive technologies, for example, such as improper handling of embryos, misuse of reproductive technology, mistakes during egg retrieval or fertilization or embryo implantation. For example, regarding the first, there are much more possibilities, but regarding to the first improper handling of the embryos, there was a 2018 case in the United States, in San Francisco, there was a fertility clinics, and the tank was under the failure, and this destroyed 3,500 frozen eggs and embryos, which have been there preserved for 400 patients, and there have been many court procedures, and just in one class action, the federal jury awarded 15 millions to 5 families. And the 19% of this was assigned to the tank manufacturer and 10% to the fertility clinics. Then also, as already Sasha mentioned, cloning is not allowed even in Slovenia, and I think in many of our countries it is not allowed. And also in Slovenia it's not allowed to cross animal and human cells. So that is prohibited, so that will be misused. And of course, very popular or very interesting are the cases of embryos mixed up. There I will mention just 2 interesting cases. There was a white couple, so-called Fazanos, which had twin sons, which have been received through the art treatment, and one of these sons was African-American child. They have been white, and they received one child, which have been African-American child. The newborn boy's genetic parents, the Rogers, sued the Fazanos for the custody of their biological son, and of course won this procedure, and the son was returned to these biological parents. That case was very important because it resulted that in all following cases, the courts settled in the favor of genetic parents if the children have been born in such procedures. There was also including Manukian case, 2019. There was a very devastating case because there was an Asian couple who went to California to seek fertility treatment and have twin daughters. They have been expecting to give the birth to the twin daughters, but instead the mother gave birth to twin boys. The twin boys were not Asian and were not even related to each other. So the 2 other biological parental couples sued and successfully won this custody over their biological children. So on the other side, this Asian couple who gave the birth to the children was very devastated. Pre-implantation genetic diagnosis, also Sasha addressed its topic, is issued to examine embryos genetically before their transfer into the uterus, and generally is defined as the testing of pre-implantation stage embryos or octis for genetic defects, for example, such as chromosomal abnormalities, X-linked diseases, or single gene disorders. And also, there are many critics related to this diagnosis because they're saying it is eugenic because it makes possible that couples can choose among all other embryos, the embryos which are related to a frivolous choice, and that is facilitate the selection of children with certain desirable physical characteristics or intelligence. On other side, to eliminate those with a genetic disorder. There's also an interesting case from United States, so-called Alabama case. You can read more about this case on the internet very shortly because it's a very large court decision. There was fertility clinic which was in the hospital, and one of other patients, not these fertility patients, went to the cryonic nursery and removed several embryos, and that was resulting in that embryos causing the death of the embryos. And very shortly, you can read the whole decision on the internet. The Supreme, it was very interesting, also Sasha addressed this topic, that the Supreme Court Alabama ruled that under the Alabama Wrongful Death of a Minor Act, the definition of a child, that is very important for us, includes those who are unborn regardless of their location, either inside or outside biological uterus. Even these frozen embryos are seen as the child. Exposure to medications used in the art process may have adverse effects on the fetal development. We are all familiar with the so-called thalidomide case. It was not related to the artificial assisted reproductive procedures, but it's a very important case because it's a pivotal case, and thalidomide was a drug which was introduced in the late 50s, early 60s, and it was initially marked as a sedative, and it was used to treat morning sickness in pregnant women. The thalidomide was used in 46 countries and had devastating effects on fetal development, which resulted in society biggest anthropogenic medical disasters ever, with more than 10,000 children born with a range of severe deformities. And of course, one of most known is phocomelia, that is you can see on the photos. There have been also many of miscarriages. The case also raised important ethical questions regarding the responsibility of pharmaceutical companies and the medical community to protect unborn children from harm. It sparked discussions about the ethics of prescribing medications to pregnant women without proper understanding of their effects on fetal development. In summary, the thalidomide tragedy serves as a stark and tragic example of prenatal harm caused by a pharmaceutical drug. It is a pivotal case in the study of fetal development and the effects of substance on pregnancy, leading to significant changes in medical practice and regulatory standards to prevent similar incidents. Yes, the success of art has been accompanied also by increase of multiple births and their associated costs. For example, the average cost, following one research, for singleton delivery is estimated to be less than $10,000. For twins is less than $38,000, and for triplets, you can see more than $100,000. The rate of twinning among parents which have undergone the art procedures is 22 times higher than that in the general. Physicians who performed art should develop effective treatment to reduce multiple births that have been suggested. As mentioned, art increases the risk of multiple pregnancies, which can carry higher risks for the health of the fetus, such as stillbirth. Stillbirth is death of the fetus in the uterus before the birth. Then the premature birth. The premature birth is when the child is born before the 37th weeks of gestation or pregnancy. And of course, also to the low birth weight, less when the child is born with less than 2,500 grams. And also, of course, for the mother, with is associated with the high blood pressure, high blood sugar, preterm labor, bleeding, placenta problems, and so on, so on, so on. A risk to the babies, particularly the risk of prematurity, are significantly higher in the multiple birth. You can see here, I won't go through very interesting information, that if there's a singletons, there's a very lower risk of prematurity. Average weight is, if the child is born in 39 weeks, is 3,350 grams. Low birth weight is just less than 6%. But if we go to the twins, we can see that there is a higher risk of prematurity. The weight is much more lower. It's about a kilo, 1,000 grams lower. And of course, there is in 53% there is a low birth weight where there are twins. And if we have triplets, of course, there is the 90% of births are preterm. That means before the 37th weeks. And approximately in 90% of births are preterm. And each baby, if there are triplets, is more than 20 times more likely to die in the first months of life. So there are many such procedures. Therefore, the use of elective single embryo transfer is increasing, as already Sasha also mentioned, especially among if there are young patients, because if even there is a patient of 25 years and they cannot create a child through unprotected intercourse, there will be just single transfer, because we have 10 more years to wait if there will be maybe successful through the nature intercourse. And then probably you know all these octomom, or which gave the birth to the octuplets, which have been born in 2009. Just to say that the children have been born in the 31st week of the pregnancy. The weight of children have been from 680 grams to 1,400 grams. So there's very quite a range. And she had already before 6 children. And all children survived and are quite healthy today. So there's a very good example. That is, there are 2 cases of octuplets recognized to be born. In order to be effective, an economical art program often aim for fertilization of more embryos than will be implanted in women for whose pregnancy the embryos are created. But how to choose the embryos? On one side, we can say we have good, good embryos and poor quality embryos. If we have good, we are going speaking about the surplus embryos. If we are having good quality embryos, they may be donated to a research program, for example, in the light of the stem cell studies. But on the other side, if we are having poor quality embryos which fail to qualify for embryo transfer or for cryopreservation, or which have been subjected to the pre-implantation genetic testing, and they have been diagnosed with a genetic or other diseases, abnormality, they can be discarded. Another word, yes, not destroyed. So you can see that is quite problem. And how can we use this surplus embryos, which are not used at that moment for the implantation in the woman? The woman can use them for own use, because if the first attempt has failed, or because they have additional wishes for additional children and they have frozen embryos. On the other side, they could be donated for reproductive purposes. For example, in Slovenia, it is not allowed that also embryos could be donated to another couples, but some countries makes possible that also frozen embryos, which are not used, could be donated to other couples. And they can be also donated for the research, of course, we have. But we have also the problem, the last option can only, for example, cessation of their conservation without any other use, because it could happen that medical authorities consider that the woman no longer meets the appropriate requirements for assisted reproductive technologies. For example, in Slovenia, years ago we had the limitation of 43 years, but then the Constitutional Court abolished this age limitation. And one more information, 2 days ago in Slovenian Constitutional Court also ruled that also single women and homosexual couples, women, have the right to in vitro fertilization. So that is the newest, 2 days ago. And then we have also the problem, because in Slovenia the frozen embryos could be stored for 5 years plus additional 5 years, but it could happen that the couple are not coming back. So the clinics do not have any information what is happening with this couple, what should happen with this frozen embryo. So they do not renew their consent. And also, very modern problem, which should also be addressed, it could happen that couples have stored their frozen embryos, but they went through the divorce. So nobody is anymore interested about these frozen embryos, or even they could happen that someone passed away and frozen embryos should be part of the probate procedure. So in America, some fertility clinics already put these arrangements in the agreements before they started with the treatments. One key aspect of art-related liability is the concept of informed consent. Medical professionals are typically required to inform patients about the risk associated with the art procedures, including the possibility of multiple pregnancies, genetic issues, complications related to the medications. Failure to provide adequate risk disclosure can result in liability for prenatal harm. There's also another problem because the legal status of the fetus is also a significant factor in determining liability. In many legal systems, the fetus is not granted full legal right until the birth, the same in Slovenia. This can complicate claims for prenatal harm. For example, they could be related to the wrongful life claim. That is a claim which could be made by a parent who argue that they would not conceive or carry the pregnancy to term if they had been properly informed of the risks. There is a wrongful life claim which can be brought by the child, arguing that or someone who is representing the child in the name of the child, arguing that the harm of the conditions suffered due to art procedures should have been prevented. And of course, we have already mentioned before, wrongful parenthood. In some cases, the art procedures might lead to mistakes in paternity or maternity, such as misidentification of sperm or egg donors. If a mistake leads to the birth of a child who is not genetically related to the intended parents, the medical professionals or clinic could be liable for the damages. And who might be liable for prenatal harm? If we put a summary, there could be medical professionals, healthcare professionals who perform the art procedures. If prenatal harm occurs due to medical negligence, malpractice, or failure to follow proper protocols. For instance, there was a mistake in embryo implantation or failure to inform patient of the risks. Of course, we also mentioned before that fertility clinics could be liable because the clinics itself could be liable if prenatal harm arises due to negligent practices such as improper storage of the eggs, failure of the tank, sperm embryos, or failure to follow safety protocols. Pharmaceutical companies, we already heard in the case before related to the thalidomide. If the pharmaceutical company could be liable if the drug was defective or inadequately tested for safety in pregnancy. And of course, intended parents. That is also a very open question because when the woman is pregnant, what happened, who will be liable if she causes the harm to the unborn child? If she is drinking, we know fetal alcohol syndrome could happen. If she is using the drugs, the child could be born with a drug addiction. So there are many questions, and so we can also, in some cases, especially in the United States, in the past have been many cases relating to the liability of the intended parents. Thank you for your attention.